SJC-12363, Commonwealth v. William McDonagh.
11, good morning. Give us a moment. You may proceed.
Thank you, Mr. Chief Justice. May it please the Court, Patrick Levin on behalf of William McDonagh. We're here on further appellate review of convictions of aggravated statutory rape and indecent assault and battery on Mr. McDonagh's son, who was 10 and 11 years old at the time of the alleged crimes. In a separate case, Mr. McDonagh pled guilty to possessing child pornography in another location about 8 months after any of the incidents charged in these indictments. And the question before the court is the propriety of the use of that evidence in this trial. If I may, I'd like to begin by just walking the court through the record as this evidence developed in the case. So the first time this evidence is brought up is at the pretrial hearing on October 30th. And the colloquy is, starts on page 18. It's approximately page 18 to 27 of that transcript. And the defense agrees that the fact that the defendant was arrested at that time is going to come into the case. It's relevant for the jury to understand the whole timeline of the case, but is arguing that the charge, the reason that he's arrested, should not be admitted, that the child pornography offense is too prejudicial. And the prosecutor offers this admission to possessing child pornography for the purpose of corroborating the victim's testimony that he was shown child pornography.
I have no quibble with that corroboration rule.
That's right.
That's not,
and
that's not why
agree.
you're here.
I agree that the evidence was eventually properly admitted for that purpose. And in this pretrial hearing, that's the only purpose the prosecutor offers it for. And the judge recognizes that that's a proper purpose for this evidence. So on day one of the trial, the defendant comes in with a proposed stipulation that would put before the jury the fact that the defendant was arrested on this date and charged with possession of child pornography. And the prosecutor requests, this is on page 208 of the first volume of the trial transcript, the prosecutor wants that stipulation to also include the fact that he admitted to possessing child pornography. The defendant objects to that and opposes that piece. The next day, they come back, and now I'm on page 215 of volume 2 of the trial transcript, and they're talking about this again. And defense counsel, at this point, it's becoming clearer that the judge is going to allow some form of this evidence to be in front of the jury. And so defense counsel on page 215 to 216 is emphasizing the reason why they're being allowed to admit this type of evidence where it's so prejudicial is because they have to be able to corroborate the fact that their witnesses are saying that they were shown pornography. And, but she says that just the fact that the pornography was found on the defendant's computer would suffice for that purpose. But the prosecutor argues that the admission has to come in because otherwise the jury might think that the pornography belonged to someone besides the defendant. So eventually they agree to a stipulation that includes the fact that he was arrested on this date and charged with possession of child pornography, admitted to that crime, but denied ever sexually abusing any child. That stipulation's read to the jury, and on day 5 of the trial, defense counsel requests a separate limiting instruction that they not be allowed to consider that as evidence of his propensity to commit the charged crimes. This is on page 159 of the 5th volume of the trial transcript. So the next day they come in to finalize the jury charge, and this colloquy is at pages 20 to 33 of volume 6. And this is the one that we've most focused on in the briefs. And so they come in, and this is the very first time that the prosecutor suggests that this evidence should also be used to show the defendant's state of mind. That's the phrase she uses, which what she means by that is the fact that he is sexually attracted to children, that he's a pedophile. Never before in the case has it been suggested that this is the purpose of this evidence. This is the last day of the trial when all they're doing this day is closings and submitting the case to the jury. And defense counsel objects to the judge including state of mind in the limiting instruction for this evidence, specifically argues that this is a propensity inference. It turns it into propensity evidence, that it causes the evidence's prejudicial effect to outweigh its probative value, and that it contradicts the other instructions the judge is giving, that they're not allowed to use this evidence to show that he has a propensity to commit this offense.
Well, the judge instructs that you can't use it for propensity purposes, right? Very expressly. So the issue is whether whether the prosecutor could argue that he's sexually interested in kids, right?
That's right. And
that's different from propensity.
So as this colloquy progresses, the judge agrees and refuses to give the state of mind instruction, but then rules that the prosecutor nevertheless will be allowed to make this argument in closing. So what she's just done is she's agreed to let the prosecutor use the evidence for a purpose that her instructions forbid. This is error.
No, because you're conflating propensity with...
No, Your Honor, respectfully.
Oh, go ahead.
She refuses to give the state of mind instruction, which the prosecutor says the point of the state of mind instruction is to let them infer that he's sexually attracted to children. The judge says, no, I'm not going to give that instruction. I'm going to limit this evidence to other purposes, but you can still make this argument.
So it gets a little complicated here. Put aside just for the moment what the standard of review is, all right? And I understand Judge Roach's comment before the closing was pretty unequivocal.
And cut off the defendant.
And cut off the further argument. I appreciate that, and I'm sure you're going to get to what you think the standard of review is and that it was preserved. But put that aside. It seems that if you look at Creighton, the issue here is, well, it may well be that this type of evidence is admissible for a non-propensity purpose of state of mind, but state of mind was not an issue in this case.
Yes.
There was a denial of the act. So the problem, as in Creighton, where knowledge wasn't really required, was who was at the computer terminal. Here, even if there had been a state of mind limiting instruction and it had been argued state of mind, you'd still be making the same exact argument.
I absolutely would. State of mind, intent, motive, none of these things are at issue in this case. And a piece of evidence, a extremely prejudicial piece of evidence, was such a high danger of being used for a propensity
I don't understand
inference.
why it's not at issue. Your person's saying he didn't do it, right? It's a pure denial, the defendant.
Yes.
But they're arguing that he's collecting child pornography, he's interested in sex with children, which makes this incredibly terrible act comprehensible. Why isn't it relevant? I understand we've got a prejudicial versus relevancy determination, but I don't understand why it's not relevant in this case. They're trying to prove that the defendant isn't a typical father, but he's rather a pedophile.
So I'm not arguing that this evidence isn't relevant. Mm-hmm. I'm arguing that its relevance comes through an impermissible propensity inference. And the reason that we don't allow propensity evidence is not because it's...
Isn't there a difference? He can be sexually interested in children and not be... he can restrain himself. Those are two different inquiries, aren't they?
But if he is... The fact that he's sexually interested in children, the only way it tends to prove this crime is through an inference that he acted in conformity with that character trait on the specific occasions that were testified to.
Counsel, aren't there a line of cases, an old line, where there's an exception under King and Lanigan, and I forget the name of the third one?
Commonwealth
and
versus
wouldn't this
Bemis.
be swept into that?
No.
Why not?
Because those cases are analogous to Federal Rule of Evidence 413 and 414. Those rules create an exception to the general bar on propensity evidence in sexual assault cases. But what they allow is evidence of prior sexual assaults. not generalized evidence about who you're
Even-
attracted to.
Even though what the evidence would be evidence of a prior crime, illegal act, in that it is possession of child pornography.
Right, but it's not a
So
sexual.
it would be all right to admit the assault, but not the pornography.
So, and a lot of other uncharged assaults were admitted in this case under that line of cases. But if you look at Bemis and the old cases around in the Bemis line, they deal exclusively with prior acts between the same two parties. King expands the line of cases slightly to include acts against other victims as long as there's a tight temporal and schematic nexus between the charged acts and the uncharged acts. But that line of cases doesn't allow a generalized evidence about the defendant's sexual character in order to prove the charged offenses.
So it's a little bit complicated what's going on here. The nature of state of mind evidence, prior bad acts for state of mind evidence, is propensity.
Yeah, I tend to agree.
But it's just carrying a lighter load. It's not trying to prove bad person committed the crime. Here, in response to Justice Kafka's question, you obviously say the evidence is relevant, but it's only relevant here for an impermissible propensity purpose.
That's just right. And I agree that in general, state of mind evidence is more or less propensity evidence. But in a case where the defendant's state of mind is starkly at issue for the jury, the probative value of that particular state of mind evidence is such that the danger of unfair prejudice from the improper propensity inference falls away a little bit.
I don't get it. I still don't get it. I mean, if he's sexually interested in children,
So that's a character trait.
and he's showing kids pornography, and he's accused of raping his child, they are precluded from introducing, I mean, that seems to be evidence that indicates he's acting on that inclination in this case. It's not general propensity evidence.
So again, I'm not arguing that the evidence was not admissible. It was admissible.
I understand you agree that it's admissible to corroborate what the victim said.
Yes,
But
what the prosecutor shouldn't have been allowed to do is say he admitted to possessing child pornography, therefore you know he's a pedophile, therefore he probably raped his son. And that's essentially the argument that's made in closing.
Let me ask you something. If the evidence was in an embezzlement case, that someone was a gambler, and they went to Foxwoods all the time, went to Vegas all the time, and now the question is whether or not this person embezzled from their employer, would the fact that they're a gambler be relevant or show propensity? Would that come in?
The fact that they're a gambler, that would not be relevant. If they were deep in debt, that could be relevant to show a motive to commit the larceny or the embezzlement.
So you'd have to be not a gambler, but a bad gambler. You have to be in debt.
Yeah, if there's a reason you need the money and that's why you committed the crime, there are plenty of cases that say that goes to motive.
Yeah, I'm struggling trying to sort. It would arguably be a different situation if the judge had said, I told the jury, I will allow you to consider it for state of mind.
That would be a different
But the
situation.
judge, transcript 6, page 114, told the jury, after closing arguments, the use of that is limited to opportunity and the relationship between the defendant and the alleged victims, not state of mind.
That's right. And to be clear, I would argue that it would have been error for her to tell them they could use it for state of mind. But the error is compounded in this case because she also let the prosecutor make an argument that she was not allowing them to use.
Right. And that's the screwy part of this, is that
Right.
it's hard to say that this is prosecutive error
In
because
fact, I
she
specifically say it's not.
presented it to the judge and the
It's
judge
solely judicial
expressly
error.
allowed it.
No, the prosecutor did everything right here.
So what do we do with a judicial error where the judge says, I will let you argue something and then I will tell the jury that you may consider it for the limited purposes, and those do not include the purpose that the prosecutor was allowed to argue.
What you do is you reverse the conviction. Commonwealth versus Lamrini is cited in the brief.
And you reverse it because your view is that it was preserved during the motion in limine, essentially, or during the
Charge conference. That the only error is what the judge did during the charge conference. The prosecutor was entitled to rely on it. So the objections made and the arguments made during the charge conference preserved the judicial error here.
Yeah, so what you're trying to say is, and I think I understand your point, please tell me if I'm wrong, is don't worry about whether or not this evidence would have been admissible on state of mind when you balance probative value and undue prejudice. That sounds like a really difficult case. It says something about the content of his consciousness that he has a state of mind, but don't worry about it because it was argued and came in for you looked at this, so that means that you are guilty.
That's right. I've argued it on several different levels in the alternative, but essentially, the danger of unfair prejudice from this evidence, as the trial judge recognized on multiple occasions, was enormous. Her jury instructions were confusing, particularly in light of the argument that she permitted the prosecutor to make. And as Commonwealth versus Creighton holds, if the jury is instructed to only consider a piece of evidence that has such a danger of unfair prejudice on points that aren't really an issue, we can't be assured that they have been able to follow that instruction.
Yeah, counsel, there's a case from, I think, in the 90s called Lanning, an appeals court case, where they permitted the admission of testimony about watching pornographic movies with a defendant who was later prosecuted for child sexual assault. Is that different than your case here?
I apologize. I'm not familiar with that case. What was the evidence?
It's evidence of the two girls watching pornographic films with the defendant.
That's very different. That's evidence of a crime. That's
But possession of pornography, child pornography is a crime too.
It's evidence of a crime against those victims.
I see. Well, all right.
So, okay, but then we have the judge telling the jury, you may not consider in her closing instructions, you may not consider it as propensity evidence. So
Judge,
what do we do with that?
Your Honor, I find this very confusing. I can't imagine the jury did a better job with it. They were confused, and they probably used it for the purpose that was implied by the prosecutorial argument, which is you can tell that he's a pedophile, so you should conclude that he raped his son.
So if we take that evidence out of the case, what were you left with against the defendant?
Well, it's not a matter of taking the evidence out of the case.
No, but I'm just curious. Like, I understand what you're arguing, but I want to know if that didn't happen, if that argument didn't happen, what would the evidence be against your client?
Well, Your Honor, it's the testimony of this complainant and the fact that child pornography was found on the defendant's computer. That's the evidence. And so that the complainant's credibility is the key issue for the jury. Everyone understands that, and the prosecutor explicitly uses this argument to bolster the credibility.
If I can just go back for a moment, now you're over your time. We have events in Suffolk County
Yes,
charged.
in Dorchester.
We have prior bad acts, sexual acts that occurred in Hull and in Cambridge.
The Hull acts are subsequent, actually, to the Dorchester acts.
Subsequent, but they're subsequent bad acts, but they're sexual acts.
That's right.
And then the child porn was also in Hull.
Well, he was arrested in Hull for possession of child pornography.
Okay,
That's right.
so when, I guess there's reference to the Hull acts, but the Hull acts were both subsequent sexual acts as well as the child porn in Hull.
So the limiting instruction about the acts in Cambridge and Hull is a repeat of a limiting instruction that the judge gave contemporaneously with the complainant's testimony about the other uncharged assaults.
Okay, and you're not claiming any error with regard to the admission of the prior and subsequent sexual acts?
I'm not. I think those are admissible under the King line of cases.
Can I ask a quick question about standard of review? So you're saying that the standard of review is prejudicial error?
That's right.
Okay, and so you're arguing that it would have made a difference in the jury's verdict? if,
Yes, it certainly could. It doesn't, you don't have to find that it would have made a difference, but I certainly think this could have been a factor in their deliberations for sure. And in fact, that I can easily imagine them bypassing careful consideration of the defendant's arguments altogether just because, well, we know this guy's a pedophile, so he's probably guilty of this.
even given the judge's instructions that you're not supposed to look at it with regard to propensity?
Well, I don't think those instructions are clear without a curative instruction that goes to the argument that was made by the prosecutor.
Thank you.
Okay, thank you.
Thank you very much.
Mr. Zanini, good morning.
Good morning, may it please the court, Mr. Chief Justice, John Zanini for the Commonwealth. With me today, Sarah McAvoy, the Trial Assistant District Attorney, and Claudia Arno, who assisted on the brief. First, there's some confusion about the judge's jury instructions, and the judge was careful to distinguish between the fact of arrest and limit the jury to using the fact of arrest on the issues of opportunity and relationship, which is transcript 6, page 114, cited at defendant's brief, page 10. And the fact is that the judge distinguished the admission to possessing child pornography and said that that conduct could be used on intent and state of mind. So in the Commonwealth's brief at pages,
Where do we find that? Which pages?
and the transcript pages are, the entire instruction is given 111 through 115 of volume 6. I set it forth fully in the Commonwealth's brief at pages 16 through 18 of the Commonwealth's brief. And you will see that the judge very explicitly in the first two paragraphs of the instruction here about the acts, talked about the alleged acts outside Suffolk County. She told them it was not propensity evidence or any evidence he had a character to commit the crime or bad character. It was not direct evidence he committed the crimes in Suffolk, but it went to opportunity, intent, state of mind, and relationship. She then went on to discuss the fact of arrest. And about the arrest, she again went through the not propensity, not bad character evidence, not admissible for direct evidence to basic conviction, but that was limited only to opportunity and relationship. So the instruction here explicitly permitted and instructed the jury very clearly this went to intent and state of mind. It was not propensity, it was not bad character, it was not that he was a bad person who might commit a crime, and it was explicitly distinguishing arrest and the other conduct, which he stipulated to.
And you're saying that those go not to the prior or subsequent sexual acts, but to the child porn?
It goes to both. It goes to both.
And
And it's clear in volume
which
3
page?
around page.
Which page are you referring to in terms of the?
So the judge, it starts at, I believe, volume 6, page 111.
Okay,
I
I've got
believe.
page 111.
And she says the defendant's alleged acts outside Suffolk County. You've heard testimony about incidents outside the county. Well, what they heard was about a small bit of prior conduct, I believe, but what they heard was also about the acts and the incidents outside Suffolk County include not just possessing child porn, but showing the children, all three of his children, pornography, showing them child pornography. And it was clear in the discussion, there was some discussion of grooming when they were discussing this with the judge. And when the victim initially testified about conduct outside the county in Hull, it was not just some sort of touching, it included the showing of pornography. And that's when she instructed about all of these acts initially. And then she instructed again in the final instructions. So I suggest she handled the issue entirely appropriately. She gave,
I mean, she then goes on page 6113, defendant's 2010 arrest for child pornography. You're telling me that the jury was to understand that the discussion with regard to the arrest for child pornography speaks to the arrest as opposed to the stipulation?
I do think that juries are intelligent and understand that. That's what I think about jurors. You may not
No,
think
but
that
I
of jurors,
have
but
great
that's what I
respect
think.
for jurors, Mr. Zaniti.
Good,
But
then we share
but
that.
to when you go on and discuss the arrest for child pornography, where the only evidence that was admitted speaks to the admission with regard to it, you mean to say that the jury understood that there was a distinction between the arrest and the admission when the limiting instruction with regard to the arrest, I believe, was the same limiting instruction given earlier as to the admission? Didn't the judge with regard to the admission?
I do believe the jury was able to understand that, and I believe in light of the prosecutor's argument, which was about the admission to possession of child pornography, that the jury would have understood that the only use the reference the prosecutor makes is a very brief reference that the possession of child pornography is the defendant is sexually attracted to children.
She used the word inclination, correct?
Yes, his inclination or interest sexually in children
Is inclination-
corroborates.
Is inclination the same as propensity?
No. Again, this gets into the whole discussion Justice Kafka and Justice Lowy are having about, there's all sorts of evidence which is propensity evidence writ large, but when it's narrowed, it's actually intent, motive, state of mind evidence, as defendant conceded about
So I
motive.
totally agree with that, Mr. Zanini. My concern is this. My concern is not the theoretical case where the judge references in the before the closing what can be argued. My concern is there's no doubt that, in my view, that this type of evidence is relevant for a non-propensity purpose of state of mind. The issue here is that it doesn't seem to have gotten argued that way. And so we don't even get to the point of balancing probative error and undue prejudice. The defendant's inclination or interest sexually in children corroborates Collins' testimony that the defendant sexually assaulted him. So the evidence is relevant for a non-propensity state of mind purpose. It doesn't seem to have been argued that way in that phrase.
Well, I don't know how else to understand the argument. His state of mind, his intent to commit a sex offense against a child is exactly how it was argued. And that does corroborate, as everyone agrees, that corroborates the testimony of the victim here and of the two siblings who testified to being shown this material. And it is, circumstantial evidence from which you draw the inference of his intent or state of mind to commit the offense. It's a common sense, reasonable inference that anyone can draw.
What if we don't accept your argument that it was clear enough for the jury? Because the judge's instructions are hard to follow. And we accept the judge gave the instruction about opportunity and the relationship, and the judge also instructed that it can't be used for propensity purposes, but left in this sort of ambiguity about state of mind. And
Well, I don't agree with that because
I'm posing it as a question because I'm not sure we're going to agree with you when we go back. Even if we don't agree, do you still win? That's my question. Meaning that if the judge was clear that it can't be used for propensity purposes, she was clear it could be used for the relationship purposes, but she kind of garbled the middle ground. I know you don't think that, but I don't know the answer to that yet. But if she did, is this still okay, and if so, why?
It's okay, and the reason why is because what you have is a passing, fleeting reference. So I went through and said, there's however many pages and however many lines, 12 pages and 277 lines of closing argument by the prosecutor. And you have one fleeting reference, essentially one sentence, a few words, in which in passing, as Justice Lowy says, inclination or interest corroborates testimony he's assaulted. Well, that was not the focus of the closing. That was not the focus of the case.
I thought you were going to argue a different thing, and I don't mean to cut you off on that, but I thought you were going to say that it is permissible for state of mind purposes, meaning what the prosecutor argued was perfectly appropriate.
Right, and I thought I
But
was
the
saying
judge kind of muddled that part of the instruction, and then what do we do?
But I don't think that the instruction was muddled. If you understand if you think, as the chief does, that the jury is confused, and that you've limited the arrest for pornography solely to non-propensity purposes, relationship and opportunity, and if that carries over to the admission of possession of pornography, because it's the arrest for the possession of pornography, then the judge's instruction is actually quite clear, and limited it solely to relationship and opportunity. And so the jury didn't use it for any propensity, and they didn't use it for anything other than relationship and opportunity. And the prosecutor's argument was proper, even if the judge didn't quite get the instruction.
Yeah, see, I'm just trying to understand that if it was appropriate, if the prosecutor argued something correct, that if a father is sexually interested in children, that's relevant evidence that should go into a rape case. But the judge didn't basically cut that out by not instructing on it, but left it ambiguous. You know, what do we do? And I may be just talking to myself, so if you're...
Yeah, I'm not sure what the ambiguity is. I mean, you either read the instruction to limit it to relationship and opportunity and completely exclude propensity.
Well, I think the judge got mixed, it may have gotten mixed up, that the judge may have said, she just forgot about the state of mind, or she just left it aside, because she expressly says it's appropriate for state of mind, but then she doesn't address it very clearly in her instructions, and that's where I get lost.
Right, but then you go to the reading that what the jury would have understood when she said arrest for possession of pornography, for arrest for child pornography. So what the jury would have understood by this limiting instruction was that the arrest and the admission are a whole, and as a whole, they are limited solely to relationship and opportunity, and she explicitly says they do not go to propensity, bad character, or any of those uses.
Can you help me out with your definitions? When you talk of a state of mind, of a particular character trait that shows an intent to commit a crime, right? That's what you said is a proper use of an intent, state of mind exception to bad acts. What then would be propensity?
Well, I never use character trait.
Okay, then tell me what is propensity then?
I think propensity is less specific to a particular act, particular conduct that's charged. So I think propensity is someone has a long criminal history and goes out and engages in all sorts of criminal conduct, let's say, and then you have a particular crime charged, and I guess the example of the gambler who commits a larceny or an embezzlement. Well, if somebody is an illegal gambler, they go to the bookie shop and they gamble, and that's illegal, and you're trying to prove that they, stole a stick of gum from the local store, it seems like, well, there's no real intent or state of mind for the larceny here, unless, as counsel says, you get to the I'm in debt and I need to go take something valuable. And then you go from propensity to actual intent, motive, state of mind. But my understanding of propensity is it's really that bad character.
So it's in the specificity, and I understand what you're saying, I agree with that. But let's just take the defendant's argument. If you're right that the instruction was adequate, if you're right that Judge Roach's instruction as it relates to non-propensity purposes was correct, just assume it was. There's still the Creighton argument that's being made here, which is that state of mind has within it a propensity inference, much more specific, as you point out, but it has a propensity inference. And here, like in Creighton, state of mind is not really the issue in this case. Certainly child pornography as to corroboration, maybe even as to grooming and all sorts of other course of conduct might have been non-propensity purposes, but state of mind is not really at issue here, which means we have to take a look at the undue prejudice. What's your response to that argument?
Twofold. One, state of mind is always at issue, especially when you're raping your own child, and it's absolutely going to be a question for the jury. Setting that aside, the notion that the possession of pornography, I think child porn is a little more offensive to most people, but as I cite in the brief, 75% of all adult men and 50% of all women have intentionally gone and looked at pornography on the internet. So what once may have been highly prejudicial evidence, like, you know, a long time ago smoking pot, smoking marijuana, evidence of that was probably prejudicial until Bill Clinton said, you know, I smoked, but I didn't inhale. And then it's no longer prejudicial after that. So I think there's a historical reality here that there just isn't this huge prejudicial effect to looking at pornography, possessing pornography. I also think the Commonwealth is entitled to put on...
Even when you're accused of, I mean, you know, yes, maybe in general in a cocktail conversation, but when you're accused of raping your kid, the stakes are a lot higher, right?
Well, that's what makes it more probative than prejudicial.
In the appeals court, 128 footnote 7 says that the Commonwealth says we should apply the prejudicial error standard. Do you change that view, or is that still the Commonwealth's view?
I think based on a close reading of the transcript, where there was no objection after the closing and no objection to the instructions and no request for a further instruction or a curative, in fact, it's a substantial risk standard that applies, and under either standard, the Commonwealth prevails.
Okay, but try my question. Do
Well,
you, in the appeals court, the Commonwealth said we should apply, that the appeals court should apply the prejudicial error standard.
Right.
Are you telling us that you stick with that, or have you changed the Commonwealth's view as to which standard applies?
We've changed our view, and